I want to bring in Nancy Tetreault. She is Leslie Van Houten's attorney, and she joins me live on the program tonight. Nancy, thank you so much for being my guest. I so appreciate it. You know, this might come as a shock to a lot of people who maybe don't follow the case because it has been going on for 52 years. But what are the actual chances, do you think, that Gavin Newsom might take this to the Supreme Court, and then after that, that the Supreme Court might actually favor your client?
Well, I think that we will prevail in the Supreme Court if it gets to that point. First of all, Leslie was not commuted from a death sentence to life with the possibility of parole. The voters in California overturned the death penalty shortly after she was sentenced. After that, she had a second trial. The jury hung. She was tried alone without the other two, without Manson and Patricia Krenwinkel. The jury hung. There was a third trial, and she was found guilty. The court imposed the death penalty wasn't one of the penalties that could be selected at that time. The judge gave her concurrent sentences of life with the possibility of parole. And she had to serve a 7-year minimum service term on that sentence. So she actually, when she was sentenced, she had 8 years worth of pre-sentence custody credits. She was eligible for parole the day she was sentenced. She has, you are correct, she's been before the parole board 22 times. And the last 5 times, the board has found her suitable for parole. What that means in California, in order to qualify for parole, the board has to find that you no longer pose an unreasonable risk of danger to public safety. And that is not an easy finding to get from the parole board. The parole board considers the record. The parole board considers the numerous psych evaluations that are very rigorous. The court looks at remorse, looks at responsibility for the crime, looks at rehabilitation, looks at parole plans. She won't just be released. She will be on parole for a number of years. She'll go into a transitional living situation for a year. Parole has conditions. So it really boils down to who she is today. She's not Charles Manson. She certainly, as a teenager, fell under his influence. She admits it. She takes responsibility for it. She has expressed deep remorse, deep regret for what she has done. And she has undergone years, decades of rehabilitative programming, therapy. She's advanced herself educationally. She really is not the same person that she was as a teenager back 53 years ago.
Can I ask you, Nancy, do you believe that if her murders, which are undeniable, if her murders weren't Manson murders, would she still be in prison today?
Manson murders, meaning Manson was the one who committed the murders? Is that your question?
He was part of the conspiracy. She was part of his family of followers.
Right. What do you mean by Manson murders? She committed the murders, certainly while she was part of the Manson family. But right. If your question is...
So the question I have is that clearly the brand of this crime was helter-skelter, summer of terror. I mean, all of the things that go along with being connected to Charles Manson and heading to the LaBianca's house that night and getting the direction from Charles Manson, who scouted, tied them up, and then ordered them to kill. All of those things are Charles Manson murders in the eyes of most people. Is it political, do you think, that she's still behind bars because it was a Manson murder as opposed to a murder that most people might not know of?
I understand your question. I would agree with that. Now, if the question were if Charles Manson were the one being looked at for parole, he was very different than Leslie Van Houten. He was not rehabilitated. He did not take responsibility for anything. He did not pass his psych exams. Very different. Your second, or the other part of your question, is this political? Well, I think it is. The board, as I said, has found Leslie suitable for parole 5 times. The governor has reversed it all 5 times. The recent Court of Appeal decision relates to the 4th reversal, and we do have a petition for writ of habeas corpus pending on the 5th reversal. And is it political? Well, you have to look at the history. back in 1988, the voters in California passed a proposition that allowed the governor authority to reverse a murder conviction. That's the only place where he can reverse the parole board's decision. And the reason, the legislative intent behind that, or the voters' intent, was so that the governor could put a stop to basically letting murderers out, even though they might meet the parole board standards. So that was his mandate back in 1988. Since then, the California Supreme Court has put conditions on the governor's ability to reverse a grant of parole.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.